Shahbaz Sharif's government clipped powers of the country's Chief Justice, depriving him of taking suo motu notice in an individual capacity.
All those in favor of the motion may say aye. Aye. All those against it may say no. I think the ayes have it, and consequently the motion is adopted.
A suo motu is when a court itself takes cognizance of a matter which it deems is in public interest and commences proceedings on it. Suo motu actions take place all over the common law world. In Pakistan, it has been a long-held opinion in the legal community that the top judge's suo motu powers ought to be regulated to prevent wanton invocation.
Article 184.3 is also colloquially referred to as the suo motu power or the suo motu provision of the Constitution, or the provision that provides the Supreme Court with its suo motu jurisdiction. Nonetheless, Article 184.3 does not explicitly mention the word suo motu anywhere. What Article 184.3 states is that the Supreme Court shall, in a case where it feels involves public importance or the enforcement of fundamental rights, the Supreme Court may pass appropriate orders. So, this provision has been used by the Supreme Court to assume suo motu powers. And we see that in the Manzoor Ilahi case in 1975, the Supreme Court for the first time excised this provision and provided relief to a politician who had been arrested without due process of law. And in the future, we see throughout in the past 30-35 years, we have seen this power evolve. In the Darshun Masih case, for example, the Supreme Court exercised suo motu cognizance when a telegram was sent to the Chief Justice of Pakistan by a Bricklin worker. So we see that the traditional manner in which cases were brought before the court, those requirements were relaxed or eased when it came to exercising the Supreme Court's original jurisdiction. Now, because the original jurisdiction, as I just said, involves the relaxation of certain strict procedural requirements, the suo motu jurisdiction of the court has also been open to critique. Because the suo motu jurisdiction, unlike a regular case where somebody approaches the court and brings a certain case, the suo motu power of the court depends on the whims and fancies of the Chief Justice of the time. And as a result, we have seen that from time to time there has been critique about the manner in which certain cases have been picked up. In the tenure of Chief Justice Iftikhar Chaudhary, for example, we saw that there was a lot of critique from political parties and from the executive that the Chief Justice was specifically targeting the government in the cases that he took cognizance of, and by excessively using the court's suo motu jurisdiction, the court was paralyzing the political government. Similarly, we saw in the tenure of former Chief Justice Saqib Nisar, there were a lot of concerns about the principle of separation of powers being diluted by former Chief Justice Saqib Nisar's excessive invocation of the Supreme Court's suo motu powers. Now, nonetheless, we have understood what the Supreme Court's suo motu powers are, and we have also understood the concerns about the excessive use of the Supreme Court's suo motu powers. But the suo motu powers of the Supreme Court are not just a concept which is restricted to Pakistan. We have seen similar powers being employed and being invoked by courts in Bangladesh and India. So as a result, throughout South Asia, we have seen the superior courts and the constitutional courts invoke their suo motu powers. Recently, in the past 2 or 3 years, there have been some important developments in our own context when it comes to the Supreme Court's suo motu powers. We have seen last year, in fact in 2021, Justice Qazi Faiz Isa took suo motu cognizance after a few journalists, a few court reporters complained about threats to their lives and their liberty. After that, however, a bench of the Supreme Court held that it was only the Chief Justice of Pakistan who was authorized to take suo motu cognizance of cases. Now, we may appreciate that Article 184.3 of the Constitution does not mention Chief Justice. Article 184.3 of the Constitution simply mentions the Supreme Court. Nonetheless, after various pronouncements which have held that it is only the Chief Justice of Pakistan who has the power to take suo motu cognizance of cases, the Chief Justice's unbridled discretion with respect to which cases to take cognizance of and which benches these cases are allocated to, such discretionary powers have raised concerns, and there have been concerns not only from the public at large, but also from people within the bench. We have, for example, seen Justice Moiz Baig, who on the eve of his retirement spoke about the Chief Justice's unbridled discretion to constitute benches. Similarly, we have seen Justice Qazi Faiz Isa and Justice Mansoor Ali Shah have also raised similar concerns. Now, given that the Chief Justices have consistently failed to regulate this power, we have now seen that the Cabinet has also tabled a bill which seeks to curtail the Chief Justice's discretionary powers when it comes to taking suo motu cognizance of cases. So I believe we are in a very interesting time where we may see certain changes to how the Supreme Court invokes the suo motu power under Article 184.3, and we are perhaps in for a time where the public may also reimagine how it views the Supreme Court's suo motu powers.